No good, Hugh.
Output.
Hilary Calvert.
Mr Chair, Tauhenere was right when he said that I was at many of the Select Committee hearings on the foreshore and seabed, and one of them that particularly I noticed was one which was made on behalf of 76,000 employers and business groups. And they were talking in particular about the preamble. They were talking about what this whole bill is all about. And what they were saying was that it was there for 6 reasons. It's here to uphold and protect property rights, to be consistent with the Treaty of Waitangi and relevant common law. It was to bring legal clarity and certainty, to facilitate economic development for Māori and non-Māori, to integrate with other relevant legislation, including the Resource Management Act, and to satisfy overall justice and fairness, including appeal rights and remedies. As has been mentioned earlier, the Prime Minister has said that unless this bill had widespread support, he would not be supporting it. These people, these 76,000 business and organisations, looked at these 6 criteria, these 6 things that this bill should be doing, and said that this bill breaches all 6 of them. The first one, would the proposed legislation uphold and protect property rights? They have a variety of things that they're saying, but at the end they say the substitute rights that the proposed legislation would create bear no comparison to the property rights assured by the Treaty of Waitangi. Even the highest category proposed, customary marine title, would restrict iwi and hapu to blocking the proposal of others as the main way to extract tangible returns, rather than allowing them to gain full benefit of recognised orthodox property rights. When they talk about would the proposed legislation be consistent with the Treaty of Waitangi and relevant common law, they say the bill is inconsistent with common law in promoting a special status of common marine and coastal area that is contrary to the common law doctrine of eminent domain, under which the absolute ownership of all land lies within the Crown. They say giving away the common law doctrine of eminent domain in relation to the marine and coastal area would leave nowhere for any current freehold land to revert to, should it not be possible to find someone to whom private ownership could pass. This could result in neglected, decaying and dangerous structures for which there would be no one to take responsibility, and that the bill expressly denies exclusivity of use of areas under the interests created for iwi, except where reclamations are completed. When looking at whether the bill creates legal clarity and certainty, they say that the exclusion of freehold land in defined areas would mean that land can become part of the common area by, for example, erosion. By contrast, land that moves beyond the line of mean high water springs reverts to Crown ownership. Crown ownership of minerals other than those designated as the property in the Crown continues until any such are found within a customary marine title group area. At that point, Crown ownership ceases and ownership moves to the relevant iwi group. Rather than, they importantly say, promoting legal clarity and certainty, the exceptions cited above demonstrate the uncertainty and complexity contained in the proposed legislation. Uncertainty and complexity. Insofar as it could facilitate economic development for Maori and non-Maori, they say this approach would also take no account of the time, effect of transactions and the ongoing refinement of terms and conditions to suit particular prospective buyers and sellers. For example, a failing market might mean the owner had to start afresh when a price moved above market to ensure a sale was not more favourable on a rising market. The opposition. Mr Chair.
Hillary
Mr. Chair.
Calvert.
This level of complexity for what should be a straightforward transaction illustrates the difficulties for economic development that could result from the proposed legislation. So it doesn't satisfy the supporting economic development for Māori. Would the proposed legislation integrate with other relevant legislation, including the Resource Management Act 1991? And clearly we're going to hear a lot more about this later in the bill, but it is Business New Zealand's view that the bill should integrate with other relevant legislation, and it fails to integrate with the Resource Management Act. As for whether it would satisfy overall justice and fairness, including appeal rights and remedies, the legislation of this kind must be balanced, but there must be concern about the differences of interpretation this bill has received, doubtless fostering public confusion. If it became law, many people could perceive the legislation as unfair, particularly in light of the kind of issues raised in this submission. On the question of appeal rights, the relationship between applications for recognition by agreement and for recognition by order of the High Court is unclear. With the responsible minister able to enter into an agreement recognise a protected customary right, it is not apparent why any group would apply to the High Court for a recognition order. The only reason would seem to be uncertainty whether the minister would be prepared to grant recognition, although there can be little concern that favouritism would be a feature of ministerial decision-making. Grants of recognition left to the minister's discretion would invite accusations of this sort. If recognition was not granted, the first further question would arise whether the group involved might then apply to the High Court. The preamble also describes this Act as taking into account the intrinsic inherited rights of whānau, hapu and iwi derived in accordance with tikanga. Tikanga is an Alice in Wonderland word. It means whatever I think it was the red or white queen, whatever the queen said it would mean, no more and no less. The preamble goes on to say that it translates inherited rights into legal rights and interests. So we are to believe that this Alice in Wonderland word, a word that can be defined by the person claiming some property in our coastal land, creates legal rights based entirely on the say-so of the claimant. We might just as well ask iwi for a list of what they want and put through a legal transfer. Thank you.
Craig Foss.
Chairman, I move that the question be now put.
Honourable Shane Jones.
Kia ora.